Hello everybody, welcome to Law 2021 Online Litigation Shape the Debate with myself, Amanda Tice from the Solicitors Group. Joining me today are Helen Swaffield and Andrew McLaughlin. In this live session, you can put your questions to Helen and Andrew and interact as the information is being delivered. Today's live Q&A is due to last 1 hour and will cover your pre-submitted and live questions. To the right-hand side, there is a chat function. All questions are submitted in private, so please ask away. If you're watching a replay, the live chat function is disabled, but you may contact the Solicitors Group for further information. A recording of today's live session will be sent out by email within the next few days, so please keep an eye out for this. So on to introductions. So I'll be hosting the session today and putting all the questions to the two speakers here. First of all, we have Helen Swaffield. Helen is a barrister and head of contract law chambers. Helen has been a barrister for over 20 years and has worked in London internationally before starting contract law chambers at Chancery Lane. Currently, she's involved in large multi-party cases involving hundreds of claimants in the High Court. She has given seminars on contract and commercial subjects and litigation. So as part of Law 2021 Online, Helen's sessions include Without Prejudice, Privilege and Settlement, and a commercial litigation update. Moving on to Andrew. Andrew is a solicitor who has higher rights of audience for civil and criminal proceedings and sits as a recorder in the Crown and County Courts. He was appointed as a court examiner by the Lord Chancellor. His wide-ranging experience in practice, coupled with ongoing training from the Judicial College, gives Andrew a unique insight into judicial thinking and therefore what you should be doing. His main area of specialism includes civil and commercial litigation, as well as all types of personal injury from road traffic through to industrial disease and clinical negligence. As part of Law 2021 Online, Andrew's sessions include Part 36 updates and witness statements. So to kick off, we'll be answering some of the pre-submitted questions we've been receiving from you. So to kick off, this is one for you, Helen. Why does litigation privilege cover settlement discussions? Or does not cover litigation privilege cover?
So just run that one again, Amanda.
Sorry, start it again. Why does not litigation privilege cover settlement discussions?
Okay, so this comes from the piece that we did on privilege and from the stadium case, where unfortunately the board minute was released to the other side as part of disclosure, even though it covered content which the litigating party said, look, this is to do with whether they settle or not. And it set the cat among the pigeons, really. And all of our litigation privilege now goes back to ENRC, which was the case of about 4 years ago, where scope of litigation privilege was put under the microscope. And I think the problem is that you cannot trust these clients to go off and have a discussion about, shall we take the money, shall we put up the money, and expect that to be covered by litigation privilege. That's the cat among the pigeons. And normally what we say about litigation privilege is once you've got the dispute up and running and you're in harness, it covers everything, all for the litigation. But the problem with this case, the stadium case, is that it's sowed a seed of doubt. And the key point was that they were all sat there in the board meeting talking about this as a resolution of the board minute. Nobody mentioned the lawyer. The lawyer wasn't there. They didn't have a kind of legal hook. They didn't have, look, we've had this in from our legal team. We need to answer the question, shall we make the offer, shall we not? Nothing like that at all. So they were sort of free fall on the commerciality of it. And the big takeaway is, don't leave them alone to talk about it. If you leave them alone, it'll go wrong. Get in there with them, because where you go, dear solicitors, you take your magic test tube of fairy dust and you sprinkle it around, and that's privilege. If you're there, the discussion is privileged. Now, if you can't be there, then they need to have something to work to. I like PowerPoint. Option 1, settle. Option 2, don't settle. I mean, it's as simple as that. But if they're discussing something from you, a letter, a PowerPoint slide, then you're anchoring that privilege. So if you can't be there in person with your fairy dust, make sure you're there with the correspondence or similar.
No, that's great. Thank you, Helen. So moving over to you now, Andrew. Will the cost of the preparation of witness statements increase as a result of the changes?
Okay, thank you very much indeed for that question, Amanda. This is a question specifically looking to be addressed in the Business and Property Court, the changes that have occurred earlier this year in relation to the content of witness statements. I think by way of a headline, the answer is yes, the cost of the preparation of witness statements will increase as a result of the changes. A number of reasons for that. The changes have encompassed both a new practice direction, as we know, at 57AC, and also a couple with that, is part of an annexure to that practice direction, is the statement of best practice, which supplements and therefore adds to that particular practice direction. Suffice it to say, the approach fundamentally changes since the rule has changed. The best example I can give in terms of the practicalities of this is, whereas before this rule change came in, you would perhaps create a series of proofs of evidence, both at the commencement of any litigation that was contemplated. Those proofs of evidence would be built on, altered as a result of changes that would take place during the course of the, say, pre-action skirmishing. You'd then get disclosure in full from both your own side, but more importantly, the other side. And then there would be a further proof of evidence, as it were, to encapsulate the latest developments. And it would be from that basis, those series of proofs of evidence, that the witness statement would come together to comply with Part 32 of the CPO. As a result of this change, however, it really demands a fresh think when you're actually putting finally pen to paper in relation to the witness statement that will be adduced at trial and disclosed in by way of exchange or service on the opponent. So it's really sort of a starting, not necessarily just from the beginning, but almost from the beginning, because you're having now to apply your mind to the new changes that have occurred. And I think that the best tip should be really start off thinking about PD 57AC and the changes that are incorporated pretty early on in the litigation. Why will it cost more? Because that process of changing proofs of evidence into a newly compliant witness statement does require a lot of thought, because the practice directions placing burdens on solicitors, or indeed those who are preparing the witness statements in the case, to actually comply with the rule, the practice direction. That will include, of course, the nature and the extent to which someone can recall an event, which wouldn't necessarily be automatically placed in a witness statement before the changes took place. So it does require the acquisition of more information in order that you can comply with the change. Another alteration, of course, is actually being very issue driven. The courts will now move away from, as it were, anodyne, scattergun type witness statements to actually demand the parties focus on the live material issues at the time. And if a witness can't comment on it in terms of those issues, it should be simply left out. The practice direction is implicitly really saying we don't want opinion evidence from factual witnesses. Again, that will require an edit and the like. And also, I think finally why it will increase costs is that there's an emphasis on using the witness's own language, and therefore there will be a bit more toing and froing between solicitor and client and witnesses to order ensure that that's a fair, effective, natural collaboration between the professionals in the case and the actual lay witnesses in the case. So there'll be a little more fine-tuning, a little less legalese, which I think will probably require a little more time. So I think that really covers the points as to why it will cost quite a bit more. Thank you very much.
Oh, that's great, thank you. So I think we're coming back to you now, Helen. How do I make sure that the dominant person of a purpose, sorry, oh, I can't get the questions right today, start again. How do I make sure that the dominant purpose of a communication is the litigation?
Oh, this is about the Sotheby's case, where they were selling a painting that wasn't original. That never happens at Sotheby's, maybe Christie's, but not Sotheby's. So, yes, and they wrote to somebody who was an authenticity expert. I mean, I don't know how they know these days. It's so clever, isn't it? They put the painting under, take all the DNA swabs, put it under a microscope. Anyway, and they said, you know, is it a knockoff or not, in Sotheby's language? And they came back and said, yes, it's fake, which is not helpful, is it? It's not what you want to be disclosing, really, for your Sotheby's at all. I don't think this case has really helped them. And they had to disclose it because the main purpose of the letter to their insurers and to the expert who was going to be paid for by the insurance, because the insurance wanted to know whether they would have to cough up or not, was really for the insurance. And they said, well, we can all, if you do this, then we can also litigation. So somebody had the presence of mind to refer to the case, but not as centre stage. The main point of the letter was to say, are you going to sort out the authenticity of this and find out whether there is exposure for the insurer? It was a byproduct, and we can also use it in the litigation. So although it was litigation privilege and there was a dispute and there were a third party and could well have been covered by litigation privilege, the dominant purpose of that letter was not using it for the litigation, but to see what the insurers would have to pay. So that was the end of the case, really. Once that expert's report, which was against them, was out, it all ended very quickly. So if you have got, you're working with insurers, or you have got a number of people who are stakeholders in the outcome of that report, you do need to do that whole thing that I used to do with the children when and still do as they're adults. You know, will you walk the dog? No. I did it yesterday. Oh, please. And then when you do this parental line, it's highly manipulative but effective. Do it for me. And they go, okay, Mum, I'll do it for you. So when you're in that situation and you want to bind the result to you, just remember that. Do it for me. Advise me on the outcome, because I've got the sprinkling of the fairy dust, and it will keep it close and within a privileged context. I'm establishing that the purpose, the main purpose, is for me, the lawyer, not for anybody else. And anybody else can have a look at it maybe, but for me, do it for me.
No, that's great. Thank you very much. We're staying with you for this one, Helen, again. How can I agree in principle to a settlement and still keep the negotiation going to ensure that I have a full settlement agreement?
Oh, this is so much of this goes every year. You know, I estimate a fair percentage of my practice is undoing settlement agreements or reviewing them. Ever so simple. We've all got WP or WP savers to costs ingrained. But it's ever so simple. If you want to snap their hands off, and I had one case actually where I don't think they knew what they had offered. Actually recently, and again, I think somebody else did this. They didn't quite realise that if they made an offer to me in certain terms, I would snap their hands off and say, yes, please, d'accordo, okay, d'accord, game on. So plenty of kind of offer acceptance, and there were some terms to it. And then they produced an order, you see, an atomic order. And I said, well, I'm not having a gagging order here. We didn't agree to a gagging order, and we're not having one. And I referred back to the email exchange, and he, relented. Resistance is futile, really, Amanda said. Just relent. And we stuck to offer acceptance. And what he should have done was say, subject to contract. Here are the terms. And I would have then sort of said, well, subject to contract, here's the acceptance. But we wouldn't have got it over the line. And of course, I didn't want that. So I was quite pleased that the barrier of subject to contract wasn't there. So if you want to keep the game going, subject to contract, that's what you have to write on it. But if you want to snap their hands off, then offer acceptance, and don't take any nonsense about putting in another confidentiality clause or an indemnity or whatever they dream up into the Tomlin order. You get what you get. If you've accepted certain terms, then that's the basis of the order that reflects the agreement. But subject to contract keeps it all up in the air and allows you to negotiate fully. You have to choose which one you want to do.
No, that's great. Thank you for that one. Moving over to Andrew now. So how do you prepare a witness statement for someone who can speak some English, but it is not their first language?
Okay, thank you for that, Amanda. This is actually, regrettably, a common problem that is seen at trial. And I speak really from now, really, without sounding too highfalutin, in a judicial capacity, because it does create an issue for a number of issues for the judge in terms of credibility of the witness. But if we just go back a stage, let's get some basics in. First of all, a witness statement is understood to be the collaboration between the legal representative and that particular witness. First point is really the language. It should be in the witness's own words, and there's a concern widespread really that witness statements generally have a little too much input in the use of words in the witness statement, and therefore there's a mismatch at trial between the witness who's giving live oral evidence and what's in their witness statement. So as I say, that's a basic premise is it's got to be in the witness's own words. Second point is, again, often overlooked or not fully understood, witnesses trust the legal representatives to get it right for them. Even though you will send a detailed letter saying, please check this, if you want it amended, etc., it will be amended. You wonder how many, on occasions, people actually do that because they place their reliance on the solicitor to get it right. And if they've not got it right, then it can create a problem at trial. Going on to deal with the question in relation to witnesses who have some English, if they cannot sign a statement of truth, which of course has been developed and elaborated recently, and the consequences that you have from not having an honest belief in the content of that witness statement, if they cannot understand what's in that witness statement, then they shouldn't be signing it, because they will understand some English, but not necessarily each and every paragraph in English in that witness statement. So, for instance, let's say they speak Urdu, by way of example. If they are fully conversant in and understand Urdu, then that is the statement in which they should sign off on, because that is a witness they can statement that they can sign up to, that they understand, they agree with it, the facts contained within it are true. In the trial bundle, therefore, should be their Urdu witness statement and a certified English translation of that witness statement. And then that allows the parties, counsel, the judge to comprehend what's in the original witness statement of that witness. And secondly, the trial bundle allows the witness whose Urdu is their main language, but has an understanding of English, to also reference that Urdu witness statement. At trial, one would anticipate there being an interpreter present at the hearing. It is far from uncommon for that interpreter not to be fully used, because actually the witness understands the question in English. And again, it's a difficulty for a judge as to where sometimes the gradual graduation takes place, where the questions are asked in English and answered in English, and then as the cross-examination develops and evolves, questions become a little more technical, a little more tricky, and then the witness is forced back into using the interpreter. Now, it's felt perhaps somewhat cynically that those who use interpreters are giving themselves thinking time. But actually, if one thinks about it, a properly constructed, clever question to the witness really doesn't provide them with that much thinking time, because sometimes the answer sometimes doesn't actually matter. It's the purpose and nature of the question that's obviously may have boxed the witness into an implausible corner, by way of example. So, as I say, this does occur too frequently, frankly, at trial. If in doubt, in terms of your understanding as the legal representative, if you're satisfied that that witness can conduct through a trial process competently and properly everything that will need to be dealt with in English, then there's no need to have a foreign language document by way of a witness statement in the trial bundle. If, however, it's a little more technical, if you are not fully understanding, they're not fully understanding in each and every word that's used, then you really should be thrown back into using a foreign language witness statement. I think the best test in practice when you're constructing a witness statement with a witness is ask them to give you feedback. In other words, you've written something down that they have told you, ask them to feed that back to you. What is their understanding of what they've just said to you? If they then start struggling with that, then it may be time to, as it were, revert to their first language, so to speak. In terms of, final point really on this, in terms of judicial feedback on this, it won't necessarily be treated untoward that a witness answers directly a question in English when they've got the benefit of an interpreter. And often I will seek to clarify that at the beginning of the process when the interpreter's sworn to interpret. And it does allow the trial to flow a little more smoothly. So I think, as I say, that would be a full answer to that. Thank you very much.
That's great, thank you. And we're coming back to you again, Andrew, here. So to what extent does the recent change to Part 36 assist defendants?
Okay, thank you. Well, as we know from the information that's been provided, the rule change to Part 36 allows interest to be claimed after the end of the relevant period, let's say the 21-day period that the offer is made, the thinking time, if you like. And I think that's the best way to think of that relevant period as the 21-day period of thinking time. Of course, it can be more, and by court order can be reduced under 21 days. How does it benefit a defendant, if at all? The only way it could benefit a defendant is if a defendant were pursuing a counterclaim in the litigation. It will not benefit a defendant at all if they're simply defending a claim. So no benefit to a defendant with a simple defence. If, however, the defendant has a counterclaim in the litigation, they can then make a Part 36 offer dealing with the counterclaim and then seek to claim the interest after the end of the relevant period. We know from the Calon construction case that there the interest claim was 8% from the end of the relevant period. And as I say, that could be a matter for the defendant, as I say, with a counterclaim to make that compromise to settle the counterclaim. The claimant on the receiving end of that Part 36 offer will then be able to appraise their client as to how to accept and the consequences of failing to accept within the 21-day thinking time, and thereafter how interest will accrue on the sum that is sought in that Part 36 offer. So that's how it can benefit defendants and how they can use it. Final point is, please remember, as I've no doubt we are all aware, a defendant making a Part 36 offer on their counterclaim is treated as if they are a claimant for the benefits accruing under Part 36. So they're entitled to the benefits under 3617 for A through to D if when they're a defendant with a counterclaim. So thank you for that. Thank you.
That's great. Thank you very much. So we're going over to Helen now. So any tips for dealing with litigants in person and negotiations?
Oh, yes. I mean, funnily enough, just one of the pupils is trying to undo something today on that, and was so busy doing a skeleton. It's beautiful, this skeleton. And I just thought, oh, golly, that'd be great. Well done. You've learned to do skeletons. But how much of that is going to be appreciated by litigants in person, I don't know. But anyway, the court will have it, certainly. It's very difficult, isn't it, dealing with litigants in person? And the problem is that when you're negotiating or trying to, which in itself is impossible to achieve, really, you have to be very clear with them about the difference between open and without prejudice, and then without prejudice save as to costs. I mean, there's no point in without prejudice, really, is there? Unless you're doing something that you really don't want to see the light of day. And it's incredibly hard. And there are some awful STT decisions where nice ladies have appeared to say, oh, my husband's really poorly and he's come to ask me, I've come to sort it out. And what she has meant is, I want to settle this. But the decision against the sister's then gone back, and the sister's dealt it back to her in open as an admission. And the court's intervened and said, no, that's not, you're not behaving properly under your duties to the court. And part of that is getting these people through the system. And I think really when you're dealing with litigants in person, you actually have to explain. Without prejudice means nobody will ever see it. Without prejudice save as to costs means that it will come to the attention of the court before the costs are dealt with. And then open means that court can look at it at any time. And you have to be really clear about that. And there is a sort of substrata of cases and decisions where you've got to avoid the risk of being seen to take advantage of the litigant in person by juggling open and WP and WP savers to cost, so that they're completely bamboozled. It's ever so difficult, I think. I have to say that the last time I was against some, a little while ago now, but actually we did in open with the court, and they walked them through into a consent situation for an injunction. sort of trying to take the burden off me. It was impossible to negotiate. They were just up in arms, you know. And I think really the judge, very sensible, when Andrew thinks about this, could see, instead of having a full-blown injunction hearing, just sort of picked up the ball and walked them through this idea of, well, do you agree with that? Do you agree? And then, of course, they said, well, yes, we would, you know. And so in the end, I thought quite deftly managed to get them into a situation of consent and giving undertakings to the court, rather than avoid having the whole, you know, conflict, really. But I could never have done that because I was the opposition. I don't know if Andrew thinks about that, you know, having to sort of manage them through the system, really.
No, I agree, actually, Helen. I think you've properly hit the nail on the head. Litigants in person have difficulties making concessions and reaching agreements with who they consider to be the opponent. You know, there's often almost like is it a trap? Am I agreeing to something that will have ramifications way beyond my knowledge is? And I think the training of judges, certainly in the last few years, is, you know, to walk and talk litigants through, not to give them legal advice, of course, because they can't descend into the arena, so to speak, but definitely to, you know, a little bit of hand-holding to encourage, as you've said, taking them through steps so that they're not challenged as such. It's not aggressive, it's not adversarial, and the like. And it is a bit of an art and a skill. And again, it as Helen and I, you know, as you, as listeners and viewers to this will know, litigants in person come in various shapes and sizes. You know, it's not one size fits all. Some are genuinely deluded. And I'm not trying to interrupt Helen's question, but just a little bit of humour. I sat on a case, a 3-day case, a few years ago now, both litigants in person. Long story short, the litigant in person at the conclusion, who was the claimant, produced 18 pages of written submissions, 16 of which were utterly, you know, really deluded, it has to be said, including the submission that I had received as the judge 3 death threats during the course of the trial from the defendant. And it, you know, was beyond belief. And so I had to clarify as to whether those death threats had been uttered in my presence or whether the defendant had threatened to kill me in my absence when the, you know, I'd rose and the case had been stood down for a particular purpose. So, as I say, that's a true story, but it just shows the nature and extent to which some LIPs can get slightly unhinged by the process. So, over to you, back to Helen.
Do you have anything else to add to that, Helen?
No, I agree. You know, it is hard, but I think if you are going to send a WP savers to cost to say something, this isn't without reason, this is what it means, and yeah, and then make your submission so you can give it back to the court at costs, and just set it all out very, very clearly. I think judges pick that cue up and can see you're trying.
Well, exactly. Yeah, I think it's meant to be fair.
Yeah.
And shown to be fair, I think.
Yeah. Yes, it's sort of how it looks from the other side, isn't it? Yeah.
That's great. I think we're coming now to you, Andrew. So how do you address the changes regarding vulnerable witnesses if the matter is allocated to the small claims or fast tracks?
Okay, thanks. These are the changes that have been made very recently with regard to really civil litigation catching up with criminal litigation in terms of vulnerable witnesses. The answer to this question is it needs addressing straight away. The overriding objective change with the vulnerable witness changes, in other words, the courts really expressly acknowledging that vulnerability of witnesses is important. It's a core and central issue to ensuring a fair trial process, and therefore the courts will expressly accommodate the needs of a vulnerable witness. The rule changes give various examples, but they're only that, of the nature and extent of which vulnerabilities occur, and you should look at those in detail. But in terms of matters that won't have a case management hearing before a judge, where you're filling in a DQ for the small claims or the fast track, you need to bring that front and centre in that directions questionnaire as soon as practicable. In other words, as soon as the defence goes in, that will do it. The other thing I can give by way of a tip, because I've seen quite a few of these over the last couple of years really, is when you're filling a DQ in, I think it's practically quite useful if you've got something out of the ordinary, put it in the covering letter as well. So it's not just within the DQ that you've completed, but also highlight it in the covering letter. Many of you will know that when directions are given by the court, certainly in the small claims and the fast track, it will be off a macro template. And it's a limited amounts of time that deputy district judges or whoever will give to those DQs that you've completed. They will be completing a template at their end. They vary from court to court, but highlight it. And it is a necessary feature. If you don't, the risk is the matter proceeds, as it were, almost on autopilot with a standard series of directions. You then hit the trial, be in the small claims of the fast track, and there hasn't been the reasonable adjustments or accommodations created to allow the trial to take place on that day. The risk is wasted costs, unreasonable conduct in the small claims. So there could be cost sanctions in the small claims, and which is maybe a higher hurdle to cross in terms of successfully recovering them if you're on the receiving end of an adjournment taking place. But definitely in the fast track, the risk of cost being rewarded against those who've not tackled vulnerabilities front and centre early on. So that, as I say, that if you like, the top tip is get it in the DQs that you're completing and highlight it in the letter. So I think that answers that point. Thank you.
Can I speak and add something here? Because last year I had judicial ire directed at me because the solicitor hadn't. I mean, I don't think the client had said, but the contracting party was represented by an individual who was recovering from a stroke. And there was quite extensive cross-examination. And I stood up because just as we were sort of gathering in the morning of the cross-examination, they had said to me, look, I don't feel very well. You need to know that I had a stroke last year and that, I don't know how I'm going to manage this. And I stood up after a while and said, look, my client needs a break. And the judge, swept it aside and said, no, Mrs. Swafford, we need to carry on. Your client's only been in the witness box for 45 minutes. And sure enough, in the next 10 minutes, there was kind of an explosion, really, one way or another. And the judge actually did look fairly mortified at that point and said, well, I'm getting right. And I, whipped them outside and with some sort of deep breathing, really. And I thought then, goodness, if I'd had actually something to point to say, this witness can only take cross-examination in bursts of 40 minutes or 30 minutes. And then they need a 15-minute break. And it may be that we have to come back another day and do this. But they cannot do this like in a sort of straight run as we would normally do. I think that would have really helped, actually. Because I was quite disconcerted by the extent of judicial pushback to finish the evidence, as quickly as possible. And you don't think to ask, do you? Is there any reason that you can't cope with cross-examination? In chief is normally okay because it's only just hello and this is me. But is there any reason why you cannot cope with cross-examination for longer than, say, and flush that out, get that in that letter, as Andrew says, and then I could pick that up in trial and actually manage the physicality of being, put under some pressure, which most people can't cope with very well, understandably.
Yeah. Well, I think it's a very good point you make, Helen, actually, and it is a bit surprising that the judge reacted in that way, because it shouldn't be. And I think that the obvious concern in any adversarial process is that someone feels they're stealing an advantage by, having the case stood down for 10 minutes because people can only take 30 minutes, as it were. And I think it can occur, but I think it's rare that those sort of slight advantages occur. And clearly, if it's set out at the beginning, as you pointed out, Helen, it could affect the length of the trial. These rule changes even envisage a ground rules hearing where someone with a severe disability, they can have the questions monitored. So in other words, the judge approves the questions that's going to be asked of a witness who's got a particular vulnerability. Now that won't necessarily be someone obviously who's had a stroke and the like, but someone who's got, say Asperger's and the like. Yeah. And as you've also said, Helen, it's not the sort of thing you ask when just before the trial starts. Are you okay to give evidence for lengthy periods of time? It's almost as taken as read. We've
got these hybrids. I'm just in the commercial court, and we've just had the clerk confirm that we can have the screen in court. And I had a while ago now to cross-examine somebody who had 2 hearing aids. And I was just thinking, in the terms of pandemic, my goodness me, time you shouted at this person from the bar to the witness box, if you had any kind of infection control, it would have been absolutely obliterated, really, because they were so hard of hearing. You had to raise your voice, so a mask really wasn't possible. And it would have been better if they had been on the screen, coming in, but from remote, and then they could have adjusted the volume, put on the headphones, and it would have been safer and better. And these sort of ideas now I think we can use to the maximum, because we can have hybrids, which is where some of us are in court and some of us come in on the screen. For many witnesses, that's the answer. I mean, overseas witnesses, all sorts of people who have who wish to have reasonable adjustments could do that. And I think if you're on it really quick, you would change the outcome of the evidence if you could manage some of those practical points. It's really important now.
Yeah, sure. And I think, just feeding off what you just said, I think remote hearings are here to stay.
Yeah. Or hybrids, or
yeah. And it's just accepted now. I think the Courts and Tribunal Service have pumped a lot of money into not just the cloud video platform, which I know some concerns about, but also purchasing lots of IT equipment and screens, sort of TV screens, plasma screens, as it were, for the courts. It would be a waste of money just to sort of say, all right, the pandemic's over, we'll just go back to where we were. So I think there will be permanent changes in that.
Yeah, I hope so.
Yeah.
Okay, that's great. Thank you very much, guys. So I have a question now for Helen. I have a case with liquidated damages. What should I know before I advise the client?
Oh, great. So if you're the claimant, yahoo! That'll be quick. Consider summary judgment. If you're the defendant, not so good. So just remind yourselves, if you're tuning in and you haven't caught up with it, that the old Dunlop and pneumatic tyre did a bit of a turn, but it's gone now. And it's been replaced by those nice people at Parking Eye and Macadesi, 2 different cases heard together in the Supreme Court, resetting the test to more or less what is reasonable. But what you're justifying is not the money. What you're justifying is the contract. So why is it that you find people who don't pay their parking because nobody would get a parking space on a Saturday. So rather than, oh, it's 80 quid or it's £100 now parking line. So, you know, it's sort of changing the focus. So really just catch up with that test again. Consider summary judgment if you've got a claimant, because very few of these fail the test. Having gone from being the worst jurisdiction in Europe for liquidated damages and penalties, we are now the best. So it's really party autonomy, eat what you kill. And if you signed it, you're very likely to be bound by it.
That's great, thank you. So moving back to Andrew now. So what is the maximum rate of interest you can seek to charge following the recent change?
Okay, yeah, thank you very much. And this is really dealing with Part 36. It deals with the change, as we've already discussed, as to the level of interest that you can include in your Part 36 offer from the end of the relevant period. And I probably said that now 3 times, but the emphasis it's the rate of interest from the end of the relevant period, because up to the end of the relevant period, interest is deemed to be included in the monetary offer that's being made. The answer to the question is there is no maximum rate of interest you can seek to charge following the rule change. So it could be 15% per annum. By way of example, it could be 22.4% per annum. It could be the credit card rates of interest that some continue to charge. The point is that's got to be made clear to the recipient of that offer, generally a defendant. In a simple case, they know what they're facing should they choose to want to accept the offer out of time. That's what their client would have to pay. The rule change comes out as a result of a case called Calon Construction. So it's actually quite useful because we already have a Court of Appeal decision that actually, funnily enough, predates the rule change, because it was off the back of Calon Construction that the rule change came about. And the Court of Appeal in Calon Construction said that there was in fact no upper rate of interest that could be sought if you make a Part 36 offer in this nature. It was a valid Part 36 offer, and therefore there was no upper limit. The solution, said the Court of Appeal in Calon Construction, was that if a defendant on the receiving end of, let's say, a significant level of interest, let's say 12% per annum from the end of the relevant period, the solution to that would be to make your own Part 36 offer by way of a proposal to the claimant, or alternatively enter into without prejudice negotiations to seek to diminish the impact of the 15% by way of example that I've mentioned. So as I say, no upper limit to that, and of course we're not confusing this interest rate change with the interest that accrues under 3617, which is the interest following judgment. So this is it's within the terms of the Part 36 offer that this question is actually seeking an answer to. Thank you.
Great, thank you. So back over to Helen now. I am suing a solicitor in negligence and they have a limitation of liability. Will that affect my recovery?
Yes. Did you want more? Yeah, no, I love exclusion because I'm just drafting a contract this morning, and I was just on the phone, and it's for a whole group of people who are going to use it. I do hate giving people lots of square brackets, choose one. They always go out with the square brackets in, and you think, oh golly. But basically, it's really swung around now, and a lot of solicitors, particularly those entering into no win, no fee, think that I can just magic away an exclusion clause which says limitation of liability. It's usually capped to the contract price or to a figure, or maybe to an insurance limit. It's not so easy to get rid of it now. But that would be the first thing I would do. I would really sit down before you enter into any kind of retainer or fee arrangements, scour through that contract of retainer with the professional you're suing, look to see what their limitation architecture is. And the key thing is, who is the person you're acting for? Are they a consumer, or are they acting in the course of a business or a trade or professional capacity? Because life is totally different. The answer to your question is completely different. If they're a consumer, yahoo, you're good. You can get rid of it, because even inserting, you should think about this for your own terms and conditions. Putting in loads of exclusion architecture. I'm suing. We've had some really big cases this year with solicitors who they've given duff advice and then they've protected themselves from that with all these exclusion clauses. And the very fact of putting in the exclusion clause is a breach of your code of conduct, because what you're doing is not acting in the best interests of the client. You're saying, you can't sue me, go and find somebody else to give you that advice because I'm not going to give it. And then the solicitor disciplinary tribunal said, well, actually this sort of thing is not acting in the best interest of the client, because you are the person who's supposed to give them that advice. So if you are acting as a consumer, you've got lots of ammunition there, particularly the Consumer Rights Act, which will blow these things out of the water. The problem is, though, if you're acting for a business suing another business or suing a solicitor firm, then I'm afraid there's very little you can do to move that out of the way, absent some of the conduct arguments that I've just mentioned. These exclusion clauses can operate to reduce your money. So it's really worth thinking before you enter into the no win, no fee. Will I beat that clause? Am I acting for somebody who can get rid of that clause, either because they're a consumer or on a conduct point? But if you're acting for a business, they tend to operate against you.
That's great, thank you. Another one for you, Helen. Can I get security for costs if the defendant is in France?
Oh yes, well this is this is Brexit, isn't it? Definitely. I mean, the problem is that I'm not sure the CPR is quite caught up with this. Actually, I meant to check before I came on again this morning. So no doubt we'll get somebody writing into there. It has now changed. Normally, I mean, I can remember before. I wonder if Andrew can, where you could get security for cost for somebody in Scotland because they were in a different jurisdiction. And then, of course, we got all European, and we had the Brussels regulation, what started out as the Brussels Convention became the Brussels regulation, where you could enforce anywhere in Europe. So the court said, well, this is peanuts. You can do this as easy peasy. We're not going to give you security for cost because they're in France. Go away and enforce in France. It's not like that now. We have got The Hague, but we don't have Brussels. Brussels is no longer with us. So you can't just go away and enforce in France. So the answer is that security for cost is now changing to include anywhere where you can show the court that it is difficult to enforce. Now, it's a moving picture because we're supposed to be entering into bilateral treaties to enable the enforcement within Europe to continue, but I've yet to see those. So at the moment you're stuck with The Hague, which is not easy at all to use. And I would think, yes, if you have got European defendant companies that are European claimant companies and you're the defendant, you need to think again and not assume that you can easily enforce a judgment against them, and look at the enforcement path to that particular individual country. And you'll find that places like Kazakhstan or France may actually be in the same bag. And whereas we have those old orders in council for places like Ghana and Commonwealth countries, where actually there are already bilateral agreements in place. And jurisdictions closer to home are actually now just as difficult as somewhere like the United States, with whom we have never had anything that would help you enforce. So security for cost is a good idea.
Lovely, thank you. So this might be the last question. We'll see how we get on. I believe it's one for you, Andrew. So how a judge is likely to enforce the BPC changes?
We may have time for another question, because I think a short answer to this is that there are no changes in sanctions for failing to comply with PD 57AC, the new changes in terms of witness statements. There was a wish to strengthen the sanctions that were in play, but it was felt on balance that just leave them as they are. So any wasted costs, any costs orders in the round that failed to comply, the ordering of redaction of various parts of the witness statements are there for the judge to enforce. But because it's and apply that power. However, because these rules are so new, it's going to take a little while for the judiciary, I think, fully to react to them. So there's maybe a little bit of leeway. However, maybe in 6 months' time, things will be changing, and that you'll expect a more rigorous approach to the implementation of the rule at, for instance, the Cost and Case Management Conference. Thank you.
Okay, so we'll see if we can squeeze this last one in then. Another one for Andrew. Where does Part 36 end and Part 44 begin?
Okay, right. Okay. What we've got to be clear about when we're looking at Part 36, it's a self-contained code. So Part 36 offers and consequences of failing to accept Part 36 offers will be controlled by Part 36. If Part 36 does not bite for whatever reason, for instance, cost consequences before a Part 36 offer is made, that's where Part 44 comes in. So if you like, you've got to really have a fairly rigorous clinical approach. Are there any Part 36 consequences as a result of this Part 36 offer being made? If the answer is yes, then Part 36 will apply, and you look at, the benefits that accrue to a defendant following a judgment, interest and costs and the like. For the claimant who's got a judgment that's at least as advantageous as their Part 36 offer, it's the fourfold benefits that accrue under 3617 as well. If, however, nothing comes out of the Part 36 offer or offers, then you're thrown to Part 44. In terms of the impact of a Part 36 offer on Part 44, if it doesn't bite, then you're at Part 44, and a judge will look at general principles contained within Part 44 to then apply the costs consequences under Part 44. I think the final point to because I've come across this recently, a number of parties seeking indemnity costs where Part 36 isn't in play. Under Part 44, there's quite a lot of jurisprudence, court cases that said conduct has to be out with the norm to justify indemnity costs being awarded against a particular party, and that really does mean what it says. It's out with the norm. Merely running a defence that won't stand the light of day because of the nature and extent of the evidence doesn't necessarily mean it brings with it an award of indemnity costs. And therefore just be a little careful about seeking indemnity costs. Also, you need evidence to show that the conduct is out with the norm. So I think that brings my answer to a conclusion. Thank you.
That's great, thank you. So unfortunately, that is all we have time for today. Thank you for attending Law 2021 Online Litigation Shape the Debate. Thank you to our expert speakers, Helen Swaffield and Andrew McLaughlin. Don't forget to join the Solicitors Group's Law 2021 online community on LinkedIn to continue the debate after the live session and to be included in exclusive offers for future events. As I mentioned at the beginning, a recording of today's live Q&A will be sent out by email within the next few days. And there's still time to buy the complete event, including recording of this live session if you haven't already. To book, just go to www.thesolicitorsgroup.co.uk, where you will also find the online exhibition. The exhibition is open for anyone to visit, and if you have booked the entire event, you can claim your free 1-hour CPD webinar from the webinar learning catalogue worth £35 plus VAT. Finally, feedback forms for the event will be sent out when the event closes. By completing this, you will receive your CPD certificate. So what's left for me to say thank you very much and enjoy the rest of your day. Thank you.
Thank you.
Thank you. Goodbye.
Bye-bye.
Bye. Bye-bye.